newspapers having wide circulation about the institution of the writ petition, so that the person interested may intervene in the writ petition. Pursuant to such notice, several interlocutory applications came to be filed, which came to be allowed by the High Court. Thereafter, by order dated 18/9/2019, taking into consideration the question of constitutional importance involved in the matters, the division bench referred the matter to be decided by the larger bench. By the same order, the High Court stated the further implementation and operation of the interim notifications subject to the appointments already made, if any. Thus, from the aforesaid, it can be seen that the original writ petitioners are always vigilant and diligent and approach the High Court at the first available opportunity. Their valuable right for consideration of their cases for appointment in the scheduled areas, districts have been taken away. They have been successful before the High Court. Therefore, in the facts and circumstances of the case, the decision relied upon on the appellants to make impugned judgment in order passed by the High Court prospectively shall not be applicable to the facts of the case on hand. In the facts and circumstances of the case, the prior on behalf of the appellants herein to make the impugned judgment in order passed by the High Court applicable prospectively deserves to be rejected and is accordingly rejected. However, at the same time, in the facts and circumstances of the case, and more particularly by causing and setting aside the appointments already made, there is a likelihood of more complication which would not be in the larger public interest. Hence, we have the opinion that this is a fit case to mold the relief. Apart from the fact that the appellant hearing selected candidates belonging to scheduled areas are already working since last about 3 years, in case appointments already made are not protected, then thousands of schools in the state of Jharkhand would be without teachers, and the ultimate sufferers would be the children of tribal areas. In view of the impugned judgment and order passed by the High Court, by which the High Court has held all the appointments made in the scheduled districts areas illegal and has further directed to go for fresh recruitment, the state will have to undergo fresh recruitment process, which may take considerable time. In the meantime, there shall be vacancies and number of schools in the tribal areas shall be without teachers. Therefore, the court has to strike the balance between the rights of the original petitioners as well as the persons, teachers already appointed, whose appointments are held to be illegal, and also the public interest. Hence, we have the opinion that while molding the relief, instead of initiating a fresh recruitment process, if the directions are issued for preparation of fresh selection list based on devised merit and based on already published cutoff obtained by the last selected candidate in each TGT subject against respective categories, it will meet ends of justice and striking the balance between the competing rights so that the persons already appointed may not have to lose their appointment job. At the same time,